Okay, so we're starting our trial briefs today. So I'm going to tell you the order of the trial. This is in Schoology. It's how to create a trial brief. So pay attention. It's a little different order if you are prosecution as opposed to defense. So you start with your opening argument, and this gives you an idea of how to do that. It's a 2 to 4 sentence summary of who you are trying. You're going to address the court, the judges, your honor or your excellency, and you are, if you're the prosecution, the state, right? If you're the defense, you're specifically defending that person, and you're representing them. So your opening argument is a 2 to 4 sentence summary of who you're trying and your major reasons why they should be found guilty or acquitted. In this, the defense goes first and then the prosecution. And then you can present your evidence. You as lawyers may present evidence from the book, things that are outlined in the text. Discuss why it's relevant to the case. How does it prove your client guilty or innocent? You're going to alternate turns until all evidence is complete. So the defense will present evidence, then the prosecution, then the defense again, prosecution, until we're done. If the prosecution runs out of evidence, the defense continues until they're done, and vice versa. And that evidence is just stuff from the text. Okay, witnesses. Lawyers should call a witness to the stand and have a series of questions as well as follow-ups to ask the witness in order to plead their client's case. All questions must be and cannot lead the witness. So you can't say things like, didn't you want to kill John Proctor? Like, whoa, you can't just do that. You have to say, what was the reason you were dancing in the woods, you know, or what was the reason you drank blood, right? So the other side can actually object if you lead the witness or if you ask a question that's not related to the case. Don't plan on an objection until you're in the courtroom, but you say, objection, counsel's leading the witness, right? They're making them say something as opposed to asking a question. Or objection, how is this related to the case, right? Or objection relevance, you're allowed to do that. So yes, you are allowed to object in the courtroom. So all witnesses may be cross-examined. The defense and prosecution will alternate until all witnesses have been questioned. Don't stop questioning too quickly. Get to the point of why they're guilty or innocent with your questions. And the most important point I can make to you is, you as the lawyer make the conclusion. Don't leave the audience or the jury to make their own conclusions, because guaranteed they'll make the wrong one if given the opportunity. You say, and this is how we know Abigail Williams is guilty, because she admitted to John Proctor that it was nothing but sport, right? So the way this will look in court when you're going in order, it'll be like your defense, witness number 1. So the defense will call their witness and they'll ask their questions. Then the prosecution gets to ask that same witness questions. Prosecution then goes, they can call a different witness. The defense is allowed to cross-examine. This is kind of like a rebuttal in the sense that you're trying to say, like you're trying to get at their true motives or trip them up, either one. Now, my suggestion for the beginning of today is to create a series of witnesses, and you're actually going to tell, go ahead and grab who you need. We're switching seating arrangements for the Crucible. All right, so where was I? What you need to do is create a list of witnesses, both the prosecution and the defense, that you may call. You don't have to call them, but you're like, these are the people we may call to the stand. Why? Because that's how it's done in a courtroom. You actually have to say who you're planning on calling. That way, the other side can prepare a cross-examination. Like, so if you know the other side's going to call Mary Warren, you really ought to think up a couple of questions to ask Mary Warren, or you pay close attention to what the other side is saying and be writing down questions as she's talking that you can ask her that would trip her up. Again, the whole point is to try to get someone to perjure themselves, because then you can prove your point better. Closing arguments. These are a longer speech than the opening arguments. The closing should sum up all of the reasons and evidence that you have used to prove your case. So you don't give all your evidence and reasons and everything at the beginning. You just give a brief summary of why that person was innocent. At the end, though, you need to bring it all together and be like, this is what I've shown you. You should directly address the judge and jury as to why they should vote for conviction, which is hanging, or acquittal, which is to let them go. Leave them with something memorable that leaves no doubt in their minds. So if you're in a group with a partner, what that means is you are splitting the time. Does that make sense? So one of you will present the opening, one of you will present the closing. One of you will present evidence or part of the evidence. One of you will question a witness. I suggest using one lawyer per witness, but I suggest switching lawyers if you have multiple witnesses to question them. So your job today would be to first start by thinking about what witnesses you want to call and what evidence you want to use from the text itself. Having both is good for a balanced case. And it's not just about calling 50 million witnesses, it's about calling the right ones, right? So think about that as you are going. Are there any questions about how to begin? Feel free to pull this up on Schoology and pay attention to it as you're going. Feel free to ask me for help as well.